Welcome to the Republican Professor. This morning in California, we have an extremely extracalifragilistically super expialidocious special guest. We have John Dillon with us, one of the attorneys of record for Miller versus Bonta, which, if you don't know this case, in California, it's very well known in the Second Amendment community because it was a district court case for the Federal District Court of Southern California, which struck down the assault weapon ban, quote unquote, assault weapon ban in California as a violation of the Second Amendment. And so we're honored to have John Dillon, who did a lot of hard work on that to make that happen, with us this morning. Thanks for being here, John.
No, thanks for having me.
So, John, I like to take people a little bit through how to find this online because this is so worth reading. So I'm going to share my screen here. And
yeah, go for it.
Yeah. So all I did was bring up, I brought up Google Scholar, and anybody can do this. You can go to case law and then federal courts, because it's a federal decision, Miller versus Bonta, and a couple things come up. I'm going to click on this top one because it's got the federal reporter there, the little F, and I like to use that. And when you pull it up, you can scroll down, you can print this out as a PDF, which is what I do. And there's your name right there, John Dillon, right there. What a name! You ever get ever get stuff for that name? that's a criminal.
Yes,
right?
John Dillinger is the one that comes up the most.
John Dillinger.
So much so that I went.
Yeah,
I went and got one of the original papers of his jailbreak, put up on my wall because of it.
Oh, that's funny. So this decision is a really good one to read all the way through. And I think it's pretty understandable. Roger Benitez was the district judge. Tell us about Roger Benitez, John.
Yeah.
What was he like?
Honorable Judge Benitez, honestly, a great objective judge. I was very happy, with his attention to detail, and he really wanted to listen to both sides, both parties' arguments. It was refreshing to see a judge that was, truly interested and wanted to understand, what everyone was talking about. Sometimes you come across judges who, that they're not that interested in understanding the truly technical details of all the arguments. They just want to understand the broad aspects of it and then rule. But we had a judge who is very interested in the case, very interested in the arguments on both sides, and he really paid attention. And he went over one of the things we constantly refer to is and he even brought it up, is there's over 14,000 pages of evidence in this case. And he said, I read every single page and every single word of every single page. So, just to sit down and think, how long it takes to read that much evidence and documentation, it was cool to see, that's the judicial system, really working there. So it was good. And, I believe he's a fair judge. And I think we got a good decision from our arguments.
Did you believe him when he said that he read everything?
I honestly did.
Yeah.
I did. It wasn't, there's no doubt when he said it, because, during trial there, he would ask pointed questions just to clarify certain things. And, the questions he asked were, you'd only ask if you were reading the evidence. So that really is invested and wants to, make a good, authentic ruling that's based off the evidence.
That's awesome. So you won this case, and I'm as I go through and I read this decision, I have it printed out because I like the paper copies, but he seemed to brush aside, well, I don't know if that's the right way to say it, but Ninth Circuit precedent, like the way the Ninth Circuit had approached the Second Amendment, and he was basically saying that's in
Yeah.
conflict with
So here's the
Heller.
thing.
Yeah.
Yeah. So the big thing that's happened, and with the newest Supreme Court decision out of the Bruen case, we really saw this. But it's funny that this Southern District Court judge of California, he was the one that actually read Supreme Court precedent of Heller and McDonald, and applied the standard of review that these cases did. The problem being is for the last 10 years, I think, or more than 10 years now, Heller was decided back in 2008. And since that time, after McDonald and I think 2011, the lower courts, the courts of appeals, not just in the Ninth Circuit, but also across the country, they developed slight variations of what they would basically call this two-part test. And this two-part test was never done by the Supreme Court in Heller. It was never done by the court in McDonald. This two-part test just kind of appeared out of nowhere in the Court of Appeals level. And so this test that they would apply, that was used by a lot of the I'm going to call them in more of the liberal states. You got maybe some liberal judges that would use this test to basically uphold every single gun control ordinance, law, or regulation that was proposed. And so for the past 10 years, you got a lot of cases where, if you looked at the overall trend of, how these decisions were going, using this two-part test, you could basically enact any type of gun control and the courts were going to uphold it. It was this interest balancing test that they get to just, states can justify it. And, they don't really have to rely on evidence. They don't have to prove that, these regulations or, gun control restrictions are actually being effective. They just have to want it to be effective and think it could be effective. And because of that, you got this bad precedent that came for the last 10 years. And in this case, Miller v. Bonta, it was interesting because, Judge Benitez, he really looked at Heller and the precedent of Heller and said, look, the plaintiffs here they're challenging this law that bans a class of firearms. All these semi-automatic firearms that the state is now calling assault weapons. He's like, well,
right.
Based off of Heller, you can't just ban guns. And there's no legal justification for that. And so what he called the Heller test is he applied this categorical test. Now, if the state is trying to ban a class of arms, well, that's it. The test is over. You can't ban something that's in common use throughout the country. And we made it clear through the evidence that we presented in the case that, look, all these guns that they want to, the term that everyone's likes to use, these things are common firearms that have been around for a long time, and they're in common use. They're probably one of the most popular. The AR-15 specifically is probably the most popular firearm today, especially the most popular rifle. Just everyone has one. And so the court said, look, you cannot ban guns that are in common use, and there's no tiered scrutiny analysis, no interest balancing applied here. It's just categorically unconstitutional. Now, what he also did, because he still, had this precedent of this two-part test, he said, well, first we're going to analyze it under the Heller test. And that's, I'm making my decision off of that Heller test. Yeah. And then he said, but because the Ninth Circuit and other circuits are insistent about using this, made up two-part test, I'll also, apply that in the alternative. And in the decision, he kind of lays this out, and it does it in a really well done way to where you can read through and truly follow along. And so
Yeah.
then he went and analyzed, the state's ban under this two-part test, and also invalidated the ban under that test.
Yeah. That's what stood out to me, because for everybody listening, this decision came down last summer, right? I remember where I was when it came down. I was at the Orange County Gun Show. And and it came up on my phone. I can't remember who it was, but it was somebody, and someone said we won Miller. And of course, I was at the gun show at the time, and so we were like, "Oh,
You
is
should
this
have
going to
just
be?"
yelled it out.
Yeah, and then pretty much like within 15 minutes, everybody at the gun show, I think, well, maybe not everybody, but everybody that was paying
Worked out
attention
fast,
was,
yeah.
it got around, and I printed it out soon after that, and started reading it. And when I read it, what stood out to me was he said, "Hey, the Ninth Circuit has Heller and the Supreme Court precedent wrong. I know I'm bound by the Ninth Circuit, but because he was a district court, so there's 3 levels. There's a district court, there's the circuit court, which is in between them and the Supreme Court, and then there's the Supreme Court. Well, he says the Supreme Court is actually higher than the Ninth Circuit, so that's the one we should use. So I'm going to use that. But the Ninth Circuit doesn't like that one, so I'm going to use the Ninth Circuit's too, and it wins either way. So, but what I now since Bruen came down, the recent Second Amendment case, that big case that was decided last month, we're recording this in July of 2022, and this was last month, about a month ago. Basically, isn't it correct that decision clarified the test and clarified that Judge Benitez used the right test when he used the Heller test? He characterized it right.
Yeah. So
Would you say that right?
Bruen was huge. Yeah. Bruen was a big decision, and it was written by the justice that I was hoping it was going to be written by, Justice Thomas.
Why do you say that? Why do you say that you wish that Justice Thomas wrote it?
I was hoping he was going to write it because, in the last 10 years, there's been a number of cases that have tried to petition for Supreme Court review, and they've been denied for, various reasons. And there have been a number of times where Justice Thomas has written a dissent to rejecting, the petition for Supreme Court review. And he's laid out some pretty good arguments, and a lot of people quote him as like, "Hey, look, the Second Amendment is not a second class right. It's not the constitutional order." These statements, if you've ever heard them, they're coming generally from Justice Thomas's dissents over the years. So it's been pretty clear that he's disagreed with, not reviewing some of these prior decisions from the lower courts, and he's wanted to clarify and really get everything right, post Heller. And so I was glad to see that, it seems like he was able to get what he was been writing and hoping to get for a good decade now.
Yeah. So,
sorry. With Bruen, so the big thing, everyone's talking and, makes national news, and everyone's talking about the fact where the subject matter of Bruen was a concealed carry restriction in New York State doing this proper cause requirement. Again, it's very similar to what California has, and we call it good cause. Basically requires you to prove that you're some special person, that you need a CCW or a concealed carry permit over the other, normal, ordinary people of the world. So they struck that down. That's what a lot of the press, a lot of the media was talking about, which was big and has ramifications, nationally. And we've already seen that a lot. especially in California. And a lot of the sheriffs had said, hey, look, no more good cause, just write not applicable, which is fantastic. But the thing that kind of went over, the head of a lot of just people that aren't involved in, the court system litigation is the striking down of this two-part test that the lower courts have been implying and using in all these various Second Amendment cases. They explicitly said, no, this test is not the proper test. You are not to use this test anymore. And then the decision, Bruen, went on to clarify, what Heller really said and how we're supposed to analyze these cases. And yes, it mirrors Judge Benitez's decision in Miller v. Bonta very well, in the fact that there's a historical analysis, a categorical ban on guns. There's no historical precedent for that, and it's unconstitutional under the Second Amendment.
Yeah. I'm so grateful for that decision. I'm so grateful that it was like you said, I was scrolling down really fast when it came down, and I was like, okay, who wrote it? Who wrote it? And then when I saw Justice Thomas, I was like, okay, oh geez.
As soon as I saw that, I started smiling before I even read a single part of the opinion. I already knew where that was going to go just based off of his previous writings.
I'd only read one of those that you mentioned, these dissents from denial of cert.
Yeah.
It was called Sylvester versus Harris or something like that.
Yeah, that was a good one.
Yeah, and you look it up. You gotta look it up. It's not very long. It's only 6 pages or something like that. But
it's a really great read.
Yeah, I think that might have been where he said he finds it hard to believe that the Second Amendment protected little more than carrying your gun from the kitchen to the bedroom or something like that. And
and
so
he really lays it out in a very real way.
Yeah.
The way that you really can't deny. If you ever want to talk to your more liberal anti-gun friends and have some good points to make, just pull up some Justice Thomas's dissent or his opinion in Bruen here, and you'll have the ammunition you need to make a good argument.
Have you ever done that? Has that ever worked in personal experience?
Oh, well, in my line of work, I deal with all this stuff all the time. I've read all of these opinions. So yeah, it is always whenever I talk to anyone who's more anti-gun than me, which most people that lean the other way are. I do make these points, and I always like to, especially when I'm talking to friends, family, even random strangers who notice a shirt or something I'm wearing, I try to be very nice and just come at it from a perspective of, hey, look, I obviously am involved in this stuff. I know a little bit, I'll humbly say. And so I always try to be like, come to people by asking questions, and
that's good.
Kind of posing problems to them, like, okay, well, what do you mean by this? And what do you think about that? And do you think this is right? And I've had really good success just on a personal level. I haven't had to cut off any, friends or family, even if they're, on the opposite political spectrum as me. Everyone knows I'm the gun guy in the family, but it's at the very least, I can always shake hands, and I feel like both sides walk away a little bit better.
Yeah, I think that's really healthy. I think that's the right way to do it.
I try, 40 years of telling people not to talk about religion or politics at the dinner table. I firmly believe we forgot how to do that in a good way.
Yeah, there's something there. So John, you seem like you have some wisdom there. Did you learn that the hard way, or are you just naturally like this? Like, just you smile, you seem like you're good humored. Is that just a personality? Is there medication we can take for that?
Yeah, I guess. I don't know if I call it wisdom. I try to be nice and humble. In the line of work that I'm in, I work with some amazing, extraordinarily smart people. So, I feel like I'm humbled every day, and I love what I do and who I work with. And so, I think every day you can wake up, you can learn something,
Yeah.
and you can better yourself or your life in some way. And whether it's through a bunch of YouTube how-to videos or, interacting with people, you will always learn something from someone. I don't care who they are.
Well, amen to that. Uh, in terms of this assault weapon ban, I think a
Mhm.
lot of people on the other side think that they can just clearly define this item, and that came up in the decision. Can you take us through the definitional issue there, and what, in terms of the definition of assault weapon? I think it came up pretty early in this, if I recall. I think it's the four.
Yeah,
Yeah.
the
So
decision does.
assault weapons defined. It's it's not easy to define. I mean, these are just stipulated, term, right?
Yeah,
It
so
feels kind of made up, but I got
it
the
is.
impression that I got the impression that
Yeah,
Benitez was not really impressed with this definition. And the definition
yeah,
is like everything, right? So
yeah. So this is the problem, and the decision goes into this, and it involves the whole history of the California assault weapon ban.
mhm,
So
yeah.
it started in '89. This is the first assault weapon ban in the country, even before the federal ban here. And the federal ban was actually modeled off of this one. But it started off by banning guns by their make and model, and naming specific firearms that were banned. And
Right.
then a couple years down the road, they added additional lists of series and different types that are kind of similar to the name guns they banned. And they did that because they felt that the first ban wasn't doing its job, so they got to add more guns.
Mhm.
And then, in 2000 was when they stepped away from banning guns based off of the name, the make and model, and they started banning guns based off of their features and characteristics, that, the things attached to the gun. And so now you have your feature-based definition is one, way people define these things, but it's basically a semi-automatic center-fire rifle, if we're talking about rifle assault weapons, that
Yeah.
has a detachable magazine. That's how it started. And then any one of this list of features. And the
Yeah.
list of features basically was, a collapsible or adjustable stock, a pistol grip, forward vertical grip, a flash hider, little things that you can attach to your gun, which have various purposes, and they're designed to do different things. But they said if it has these things and it has a detachable magazine, which means, early on it meant if you press a button, you can release the magazine.
Yeah.
Now the state has
Yeah.
redefined what detachable magazine versus fixed magazine is, 3 times over after that. But
Yeah.
that was the definition back in the day. And so since 2000, they've amended it at least 2 more times, if not 3 times. I'm kind of losing track at this point. And each time they redefine, certain features, they add certain features, or they even add like a whole class of firearms. The most recent change to the assault weapon law was actually done while we were in litigation challenging
Mm.
the assault weapon law, and they added a whole new category of assault weapon called assault firearm, which is a gun that's not a rifle, it's not a pistol, it's not a shotgun, but it's a firearm. And
Mm.
they made a whole new assault weapon definition based off of that.
Mm.
So this whole thing with this ever-changing definition that keeps getting expanded and keeps trying to lump more and more firearms into it. Yeah, the court wasn't, very impressed with this ever-changing nonstop definition that has no end. And the arguments that were made at trial too were, hey, we're a state, we're allowed to experiment with our laws,
Right.
and that's why we amend this stuff. And I think one of the points that was made in the decision was like, look, you've been experimenting for 40 years, and we really haven't seen a benefit here.
Yeah.
So to say that this is just an initial experiment and you're still fiddling with it is kind of a joke to say, and I don't think the court was impressed by that. And that's just
Yeah.
one of the many reasons. But yeah, the features that are associated with what people call assault weapons, they do not increase the lethality or the killing ability or the mass murder ability of the gun. In fact, they make it more accurate, safer, more handleable, and
Yes. Right.
my wife's not the same size as me. If I pull a rifle with these features and I'm able to adjust the stock, I can literally hand it to her and she can fit it to herself to where she can properly handle and safely handle that gun like it's her own and like it was fitted to her in a matter of seconds. So there's
Yeah.
amazing self-defense benefits to the guns and the features that are associated with them.
Yeah, that's what I was impressed with his with Judge Benitez's opinion here, was that his decision was that he went back to the issue of self-defense over and over again. And he kept hammering that in there, like, okay, you're experimenting. Okay, but at what cost? At what cost to civil liberties, right? And the Supreme Court has already said the point of the Second Amendment is self-defense. That's what's protected. And the police are not always around. And it's pretty clear that if you're saying, Mr. Attorney General, if you're saying that these make it more dangerous, well, but what he say is all guns are dangerous. He says that's kind of the point. Like if you're using them for self-defense or anti-crime, they have to be dangerous for the criminal. I mean, that's why police carry guns, right? Because it's dangerous for the criminal, right? And it's good for self-defense for the police officer. That's the whole point of carrying these kind of weapons for the police, because the police need to defend themselves when they're carrying out the law, and ordinary people need to defend themselves from the same kind of crappy things that happen, like murder and stuff like that.
And he actually references specific self-defense situations that have happened, where people used
yes, that's right. That's right.
Because part of the state's argument is like, oh, these are not self-defense, weapons. And it's like, no, not only are they, can we point to, actual circumstances where they were used in self-defense is, part of the evidence under that two-part test that we had to argue under in the alternative here was that not only can they be used for self-defense, they're actually ideal for self-defense. And then the other aspect that Judge Benitez and the court looked at here was, self-defense is one aspect under the Second Amendment, but it doesn't negate the fact that, there is a militia aspect under the Second Amendment. And, we may not have a need to have a citizen militia formed to stop, an invading, tyrant or even an internal tyrant at the moment. But that's still one of the reasons why you have the Second Amendment, is so we can do that and protect ourselves individually, but also as a country. And so part of this decision, he always said, not only are these guns that you're trying to ban, not just rifles, but pistols, shotguns, everything, not only are these guns good for self-defense, but they're also ideal for militia use. The fact that they're common, everyone has them, their parts are interchangeable, people can show up and everyone knows how to use it because everyone has them. These are all things that are important for the militia if the need should ever come. And, people like to scoff at stuff like that and say, oh, no, that'll never happen. You're crazy. You're just some, right-wing nut job. And look, I'm not saying it's likely. I'm not saying it's going to happen anytime soon. But you are ignorant of history if you think that a civilization will rise and never fall. It's just, I'm sorry. that's what happens. It's inevitable. Eventually it will happen, may not happen in our lifetime or even our kids' lifetime, but conflict always arises, whether it's internal or external. It'll always be there. You cannot name me a civilization that has never fallen.
Right. Right.
And if you can, it's because it's brand new like ours. Because in the grand scheme of history, we are a baby of a country.
Yeah.
So I don't like when people try to say, oh, but if and when that ever does happen, people are going to be very glad to have the ability to defend themselves. And, the most, recent kind of similarity, when Ukraine, they started arming their own civilian population because they're being invaded.
Right.
Are the chances of the US being invaded similar than Ukraine's? No, but everyone was very willing to support Ukraine and the arming of its own citizens, in that circumstance. But I think we just live in a very wonderful life these days to just have the ability to scoff at the notion that, bad things could ever happen in our country. So I think generally, bottom line comes down to it. It's like the militia argument's an important argument.
Yeah, and I think a lot of people don't realize that the California still has a militia, and there's a code, right, in the statutes that defines the California militia, right? There's an unorganized militia. Are you aware of this? Yeah.
Yeah, so the way that the militias have always worked out historically and everything, and we had a retired General Youngman. He provided testimony in the case regarding militia, was militia, which would most aptly be like our National Guard. And then there's the unorganized militia, which is the people, we the people. And yeah, so in the times where you need to, bring the unorganized militia together, they need to be able to have arms that they're going to use in the militia. And what better than these guns that California tries to prohibit?
So, John, how did you get interested in firearms? Did you grow up with firearms?
No, it's a kind of funny story. So I grew up, didn't know anything about guns. I think my dad had a couple old war guns that were passed down to him. When I was a kid, I found out that they were in the attic, and apparently I kept telling all my friends, hey, we got guns up in the attic. And so my dad sold them off because he was worried I was going to crawl up in the attic and then do something, I guess. So I'm still a little resentful that he sold some historical guns, but
yeah,
I understand. So I wasn't around guns at all. I would admit before college, I was ignorant to history and to politics and constitutional rights, and I had no interest in it, to be honest. And got through law school, went to UCLA. It was a history major, which sparked the interest a little bit more when it came to just what we went through as a country and what brought us here today. And then I decided I wanted to go to law school while I was in undergrad. And in the first year of law school, I had lectures that were very far apart. I think one ended at 1 p.m, the next one was at 9 p.m. And anyone who's lived in LA, the traffic is so horrible. I didn't want to drive home and then drive back and have 6 hours of traffic.
Did you say you went to UCLA law school?
No, I went to UCLA undergrad, Loyola Law School for
okay.
law school.
Yeah, well, both of those places have bad traffic, especially Westwood. Westwood's really bad.
And I lived in Westwood at the time, and so I'd drive from Westwood to downtown LA to go to law school, and wasn't about to do that in between classes. But a buddy of mine, we realized that there was a gun range kind of down the street from us, and we're like, hey, we're old, we're 21, let's go shoot some guns, we're adults. Not knowing anything. And so we went and shot and took a lesson and got to do shoot some random handguns and kept going because this was our kind of break of the day to try to get out of the the brain melting of law school. And so that got me into it to the point where I went and bought my first gun. And I thought I could just show up and buy a gun in California because I was still ignorant to all the rules and regulations then. And I think it took me 2-3 weeks to figure out all the paperwork I needed to get everything organized and together in order to get a gun. Because I'd come in and be like, well, here's my ID. And they're like, oh, you need second proof. So I'll go bring my second proof the next day. No, you gotta get this and that. And
Oh man.
So finally got a Glock, a Glock 21, and started shooting more regularly and really started kind of diving into the personal use aspect of it. Still ignorant to the law and everything. But then I was on a forum one day and I had switched my barrel out on my Glock and got a match grade barrel, but it also had some ports on it. And I read something on this forum where guys, oh, that's illegal to change your barrel on your handgun in California. And I just panic. I read that and I'm like, oh my God, I committed a felony. And I literally go to the law school library and I start researching California gun law in order to, get my defense going for when the ATF breaks through my door and, arrest me for changing the barrel. I was in sheer panic mode.
Oh, man.
But I started reading all the laws under that circumstance and figured out that no, the guy was wrong. I didn't do anything illegal. And then I was like, started reading all these regulations and I'm like, wow, this is.
But the fact that it was believable. It was like believable for a second that it was totally believable because there's no common sense on any of this. It's not like you can just check common sense. Like, it's not like the law against bank robbery or something like, I never panic that I'm a bank robber because it's like common sense. Like, you're only a bank robber if you've carried out this overt action that harms people.
Oh yeah. In California, you can literally go to a store, buy a part, completely legal, pay for it, bring it home. It's illegal to have, possess, hold, everything. But then you stick it onto your gun, even though it doesn't do anything to change the gun. Now you're a felon. It
doesn't hurt anybody.
Absurd. Yeah. So I started the rabbit hole of just researching it like crazy. And that's what got me into, constitutional law and Second Amendment. And that kind of snowballed through law school. There's no books and stuff for classes at law school about Second Amendment. I distinctly remember in my con law class, the lecture in law school.
Was this pre-Heller?
We did the First Amendment. Let's see. No, this is post-Heller, which is even more surprisingly. So we do the First Amendment, spend weeks on the First Amendment in law school.
Oh, yeah.
And we do the Second Amendment, and he just reads it, and he says it's regulated to the militia next. And that was it. No other talk about the Second Amendment. I think we read like 2 cases in the case book, if there were any.
The Miller case
and
or
that
something.
was it. And so I realized, like, oh, if I'm going to learn this, you got to do your own research. So that's when I just started, looking up penal code sections online, and that's kind of how it snowballed in this. And then after getting my license to practice and everything, and working a Carlsbad firm, I convinced the partners there, like, hey, look, gun law is a big thing in this state, but there's not a lot of people doing it. And the few people who do, a lot of them are more criminal lawyers that deal with gun stuff because they have to in criminal defense stuff, but no one does any of the, civil action stuff. Or there's, one guy, I could think of there's Chuck Michelle, especially at that time, is the only one I knew of that did any of this kind of stuff. And I was like, I feel like we need more people doing this. And so I convinced them to let me do it. And
that's cool.
So I ran that kind of practice for a while. And then right at the beginning of COVID, literally the same time we went in our first lockdown, I decided to branch off, start my own firm, and do this on my own. So that's the story of how I got to where I am. But it's really just started with, I went shooting and enjoyed it. And then I couldn't understand why I couldn't have certain things that did no harm to anyone, and didn't create some catastrophic nuclear bomb that we're talking that
Yeah.
oftentimes gets referenced. And it just, reading these things, when you sit down and read them, they don't make sense.
No.
Like you said earlier, common sense does not come into the thought process.
And
that bothered me. I don't
that's
like
the
that.
anxiety. That's the anxiety, is because how do you, because no one can read all that stuff, right? I mean, you can, because
Oh,
it's your job, but most people,
yeah, it
I
took
mean,
me years to get through, it,
yeah,
just to get it through one time. And, I still have to reread it all the time to truly understand it.
right. And so, and sometimes they seem to conflict. They don't really make a lot of sense. It's just, a lot of it just seems made up. And so there's no help from common sense to keep track of it. Like, that's because common sense would be like, okay, something's criminal because it hurts innocent people, right? That's kind of,
Yeah.
but like, this is what I love about this topic, John, this Miller versus Bonta, because when this so-called assault weapon ban went into effect, what a lot of people don't understand this with the bullet button thing.
Mm-hmm.
But what in fact happened was somebody could go from model citizen one day, like Eagle Scout, and they have a bullet button that's not registered. The next day, they're now not only a criminal, the worst kind, a felon. They're a felon.
Yeah. Mm-hmm. And it's unconscionable to me that,
But there's
you
no
can just,
overt act, overt act.
Yeah.
They didn't do anything. So in other words, they could be
everything
in
you
a car
bought was
accident.
perfectly legal, and
Yeah, they
now
could be,
one day you're a bad
yeah.
guy.
Let's say you're in a car accident, you're in a coma, and the coma lasts for, I don't know, however long, not, weeks or month, maybe a month or something. You go from when you were in the coma, you began the coma, not a criminal. You come out of the coma, you're a criminal
Oh yeah,
you did
well,
nothing. You didn't need,
you,
you
you
were in
don't
a
even
coma.
need a coma. So listen to this. So there are people that, the guns were passed down to them. And so, their father gave them a gun or rifle, 20, 30 years ago. And they're not big on shooting. So they, put that gun in a safe, and that gun is sat in a safe for 20 years. And they don't constantly read up on all the new legislation that's passed, you know, every year, like most people don't. And they're not like big gun people. They just were given a gun, they put it in the safe, it's sat in the safe for years.
Right. That's,
And
yeah.
then I get calls still to this day. We're like, hey, I got a gun that was given to me. I don't know anything about it. And I'm like, look, man, that's illegal. You're felony possession right now. You can't have that gun. And they're like, what are you talking about? Like, why? It's like, my dad didn't break the law getting it. And he's like, I was like, no, they just passed a law that says that if you own that gun, it's now illegal. And they're like, well, when did they do that? It's like, well, they do it. You just don't hear about it. It's not like you get a little notice in the mail saying, hey, just in case you ever own one of these guns, we're going to be making this illegal now. Like, in order to keep up to date with all this stuff, you got to have, Google alerts. You got to be following along. You got to be heavily invested in this type of legislation in order just to keep up to date. And people have a difficult time doing that. I mean, I can do it because it's my job. That's what I do. But, an everyday person who has their own job that has nothing to do with this type of stuff, family, kids, everything else that comes in life, it's unfair. Just the bottom line, it's just unfair to think that owning a piece of property is now magically illegal and now magically makes you a felon, to where, like, and you got to think about, like, a felony conviction is not something that's just like, oh well, don't worry about it. Voting rights, Second Amendment rights, like every job you ever apply for, and that's going to always pop up. It's life changing. And it's just absurd to think that a completely law-abiding good person that's done nothing wrong their entire life is magically a bad guy because they didn't change a part on their gun one day.
Yeah.
It's
You know, some of the rhetoric on this when
it's
people,
infuriating to really, the
yes,
longer you think about it, it's just like absurd,
yes, it
you know.
is. I think it is appropriately infuriating. I'm glad that comes out because I think a lot of people in the middle, they don't, when they hear the truth about it, when you cut through the rhetoric and all that, and you just get at the truth, like you can go from criminal to non-criminal in less than a minute, midnight to 12:01. It's just a matter of passing time. It's not anything you did. Like,
Yeah.
to become a criminal for a bank robbery, I have to actually go rob a bank.
Yeah, there's
You know,
at least
I
an
have to go do
affirmative
something
action that is
or
required.
plan. I
Yeah.
have to plan
And
on it,
this, you don't
or,
even have to do anything.
yeah,
Yeah.
this is like, there's no overt act and there's nothing that harms anybody. And people talk about
No,
banning guns. You're really banning people. You're
no,
criminalizing
when
guns.
you're
You're
talking
criminalizing
about,
the person. It's the person you're
yeah,
going
when you're
after.
talking about banning guns, this is what you're talking about. You are talking about changing people's lives for the worst. You're talking about making people criminals. And you're talking about, in the end, you're talking about police kicking down people's doors, searching their house, tearing their house apart, taking their property, and arresting them because they own something, not because they ever did anything bad with it, not because they've ever threatened anyone, not because that gun's ever been used in any type of crime whatsoever. Just the simple fact that the angle on the grip is like this and not this, it's 15-degree difference. You get to, now you're saying, because your grip is different than I want it, we get to tear your life apart and potentially ruin your life in multiple ways because you have the wrong grip on your gun. And I like, we were talking earlier, when we're talking just to normal people, like, that's what I always bring up. Like, you are literally, you're advocating for tearing someone's life apart, tearing someone's family apart because they hold their gun like this and not like this. And that's it. And once you get down to the brass tacks of that type of stuff, it's not only scary that people could support such a notion. It's, like I said, it's infuriating. It's like you don't understand what you're saying when you're saying, oh, we need to ban these guns, because you have not thought about the true implications of what you're advocating for.
Yeah, John, you seem okay. So this is important for people to get. John's on the front line of this stuff. He went to UCLA. He was a history major. You probably were like a normal college kid, like, and you did normal stuff.
Irresponsible as anyone.
Yeah. And you like to have a good time. You're not like, you didn't grow up in a militia in the mountain in Michigan somewhere, in the out woods, with your own grenade launcher when you were like 5. You just were a normal guy, and then you were going to law school. You decided to go shooting one day, and I'll buy my own gun, and then just noticing like all the complications of just even that, just at that learning period, getting leveled up on that. At this time when you were buying that gun and you were going through that learning period, how were you feeling? Were you feeling like, was it starting, were you saying, did you feel, oh, this makes sense, like I need this other ID or whatever, the various barriers, was it making sense to you?
No, not at all. It's, it made zero sense. It's, I'd give them something that show where I live, and they're like, well, no, that's not an approved, proof of residency. It's like, well, this is where I live. This shows you where I live. What else do you want? You want another thing? Oh, no, that's not on the approved list of,
Right.
type. We need these documents to prove where you live. And I'm like, dude, like, I rent out an apartment. Like, what do you want? And they're like, oh, well, bring your lease in. And it's like, all right, so bring the lease in, but the lease address doesn't match my ID address because I got my ID when I'm like, 16, 18 years old. So has my old house address where my parents still live. And I'm sitting there going like, look, I live in this state. I'm a citizen in this state. I have never broken the law. Just give me my gun. And then, you find out after you do all this, oh, you got to wait 10 days for your cooling off period. And I'm like, what am I cooling off about? And they're like, well, you could, shoot someone. I'm like, huh? And so I'm going to think about it for 10 days and not do it.
Where they get 10
You
days
know,
from? Yeah,
yeah,
it's
well,
amazing. Like
it
that's the
like,
end of these mass shootings, is because if the guy only had 9 more days,
yeah.
he would have not done that. Well, what are you
Well,
talking
and
about?
it's one of the other
He's
cases I'm
crazy.
doing is the Jones v. Bonta case is the challenge to the California's ban on firearms for anyone under 21. So basically, if you're an adult 18 to 20 years old, you can't buy certain firearms.
Mhm.
And I thought that was ridiculous. But just to again, let's just break this down. The whole argument is like, oh, 20-year-olds or 18-year-olds are impulsive and reckless, and we can't trust them with firearms. But okay, so you're saying a guy, he's 20 years old, he's not safe, he's impulsive, and he's reckless, but he turns 21 24 hours later. Magically, he becomes like his brain develops and
Yeah,
he magically becomes this safe, responsible citizen, but now he can buy it. That's just a load of baloney, for lack of a better word. um, it's insane to try to make that claim. And anyone who's like, oh well, we had the mass shootings, or I think it was an 18-year-old, 20-year-old that just recently happened.
yeah,
Is anyone really trying to claim that if this guy did it, he waited a year to do this planned attack, he wouldn't have done it? Arguably, if he waited a whole another year to plan this out, he probably would have done it better.
yeah,
And his brain's not gonna magically change into some like good person. You have a
yeah,
psychopath who wants to murder children. He's not going to turn 21 and then magically become this wonderful person who's going to be, a kindergarten teacher. It's
yeah,
just not going to happen. You're dealing with, bad, evil
yeah.
people
Right.
that are all sorts of messed up.
Yeah.
The difference between 20 and 21 is not going to matter. And
Not to mention
when you're an adult,
he drove to where he drove a car legally
yeah, and
to where he went. But no one's talking about taking car rights away, car driving
exactly.
privilege.
And again, the bottom line is, if you're going to say that a 18, 19, 20-year-old adult who has every right that every other adult has, they can be shipped off to war all over the world,
Yeah.
get killed or kill others, but we can't trust them to have a gun within their own home. Like if you're 18 years old, you're living on your own, you have your own job. Yeah, you should
You
be
can
able
vote.
to have a gun. You should be able to have as many guns as you want to protect yourself in your home. I don't care.
Yeah. You can
And
vote.
so,
You can
yeah,
vote. You can
all
be on a
these
jury.
things. Yep. It's just, you don't get to parse out rights because you make up these arbitrary lines that
Yeah.
you decide people need to cross before they get the benefits that everyone else gets. It's absurd.
What's the status of Miller versus Bonta now? Is it at the Ninth Circuit? What's going
Yes.
on with it now? Okay.
So
Do
there
you have a
is.
panel? Is there a panel? Do you know
Yeah, so
which
the
judges are
panel
on it?
decision already came out,
Oh, it did.
and so
Okay.
we were successful in eliminating the state's ban on semi-automatic centerfire rifles. They also upheld the decision to require the hunting license, but because of Bruen, there's more going on there. I'll say that, and so there's lots to do.
Okay. So you're pretty busy, I bet.
Yeah,
Um,
with the Bruen decision coming out, it changed things. And like I said, think about it. There's 10 years of cases that have applied this two-part test, which has been ruled to be the wrong test.
yeah.
So when you think about it,
All
we
those
get
can
to
be
we got to go
relitigated.
back 10 years of cases, and we now have grounds to relitigate every single one of them if they were decided based off of this two-part test. And this is proper. It's that how it should be, because that two-part test was just a ridiculous test.
Yeah.
And it should have never been used in the first place.
The test, when you read it, it's got the lingo that sounds objective and sounds like, legit to some people, I
Yep.
guess. But once you dig into it a little bit more, it's kind of biased, right? It's biased toward the government, is what you're saying. right? So
100%.
it always gives the government the leeway, the right of way
Mhm.
to win.
Yeah, and so one of the things they do, it analyze under these tiers of scrutiny, which is strict scrutiny, intermediate scrutiny, and rational basis. And they all had different standards. Strict scrutiny obviously having the highest standard, rational basis having the lowest. And like you said, they'd use all this language to be like, oh no, this is like a true proper test. And then they'd go, oh, and we're going to use intermediate scrutiny in our analysis. And so if you just read all of those things, you're like, oh no, that's a good, fair thing. But when you see it in action, it's not intermediate scrutiny under any standard. They basically more than once they upheld various Second Amendment stuff and prohibitions, restrictions off of intermediate scrutiny that offered literally no evidence in support. They would claim stuff, but then they never support it with evidence, and it would still somehow survive intermediate scrutiny.
That would be the lowest one. That would be rational basis then, because rational basis is like, it's like if you can conceive, if someone somewhere can conceive of some possible reason why the government might want to do this, okay, they can do it.
Yeah. And so they literally they try to mask it as intermediate scrutiny, but they were just applying rational basis to everything. And I don't agree with even applying any of these forms of scrutiny. And Bruen affirmed that, but it's just one of those things that they could literally move forward on any gun control law, like any restriction you wanted to put, any restriction the state wanted to put in place. The courts were justifying it off of this, fake scrutiny analysis, two-part test. And so, and you saw a lot of it, part of the decision in the Jones case from the Court of Appeals, they talk about how, in the concurring opinion, he's like, look, the way you guys justify this, you could justify anything. And there's no end to
reductio ad
how
absurdum.
you apply this standard.
So it reduces to absurdity.
And that's the thing. But the normal people on the streets, and when you see the media and people doing their 15-second snippets, they don't see that, they don't understand all that. It doesn't come across well. And so
is that just lack of attention span, John?
The abuse. Sorry?
Do you think that's just a lack of attention span on people's parts, John, or what's your theory on why people in California don't get more upset about this? Are they just not paying attention, or do they just
I'd say a lot of that. This may not be popular opinion, but I think we have some of the most ignorant voting in the country in this state. People they vote party line. I'm Democrat, so I vote for all Democrat stuff. Or even opposite, Republican, I vote all Republican. Although I'd say the issue is more on one side than the other. I'll let everyone figure that out, which side has the problem. But it
is hard to
don't even understand what they vote for in this state, but yet they're adamant about voting for it. And it's why we're in the state we're in and how bad everything's gotten.
Do you feel like when you were at UCLA, that you had the same view of the students? Did you feel like the students were sloppier than they should have been? Or
so I have to be, admittedly, when I was in undergrad, I wasn't the most academically inclined. I got myself through there, but I'd say, I don't believe that the critical thinking that used to be in universities is being applied anymore. It's, you go into a lecture, you're told this is what you think, and that's it. There's
a lot of peer pressure too, right? I mean,
well, a good example, I remember, this is actually in law school. I was in, I think, a torts lecture, and they were talking about something that the professor started talking about the NRA. And I, again, at this point, still new. I think I just bought my first gun a week before. And when I bought my gun, they're like, would you like to become a member of the NRA? And I was like, sure, that sounds nice. And so I'm sitting in lecture and she's kind of spouting off about the NRA. And she goes, is anyone a member of the NRA? And I'm just being an ignorant idiot. I'm like, yeah, sure. I signed up last week. I think there's 150 people in that lecture. I was the only hand that went up. And I'm like,
Wow.
my buddy leans over. He's like, yeah, that was a mistake, buddy. Put your hand down. And I was like, oh, sorry. Should have paid a little more attention to what the professor was saying at that moment.
Yeah, that's a lot of
But
peer
yeah,
pressure.
the peer pressure's there. I think that these days people are going to all universities just to be told what to do rather than to think for themselves. And frankly, I'm not a big fan of them. I got 3 kids, and if every one of them said, I don't want to go to college, I'd be like, good for you, man. What do you want to do?
Yeah.
I'm not seeing
Figure something
a
out.
huge downside like my generation was told, got to go to college.
Yes.
If you don't go to college, your life's ruined.
Yeah. Right.
I think times have changed, and
Yeah.
the way teaching has changed for sure.
I hope so. The issue of college versus not is I think only going to get more pronounced as we move on. And I teach college, and I'm horrified oftentimes when I walk on campus, because I've actually, John, I've worn an NRA hat after Trump won.
You want to get jumped.
I
don't
wore
you?
an NRA hat to Loyola, where I was teaching. Loyola, not the law school, but the
My
undergrad.
wife went to LMU.
Oh, is that right?
Yeah.
When did she go there?
06 to 2010.
It's possible I had her in class. Possible. I did
All right.
teach a required course, philosophy.
I'll have
So
to
yeah,
ask. She might have.
sure, yeah. I had another question about where you see this going. Oh, I know. I had a question about you're a history major. I noticed that Judge Benitez is Cuban, and I noticed that, and I know you're not black or Cuban, but I noticed that Clarence Thomas is kind of hard to miss. He's black, and he grew up in the segregated South.
Yep.
I mean, Clarence Thomas grew up in the South when there was a real Klan, and it
Yeah.
was real and it was scary. And so do you think that has something to do with their ability to see through some of this stuff, and to see through
mean-
the levels of scrutiny game?
How can your life not have an influence on how you come to a decision? So I'm sure it does have an effect. I don't think either of them have ever come out and said anything like that.
Right.
But
well, there's a lot of Klan stuff mentioned in the McDonald decision, actually.
they do reference the multitude of
14th
racist
Amendment.
gun control laws, which kind of were some of the first laws that were ever passed on
That's
firearms.
Yeah.
Was all against free blacks and slaves.
Yeah.
So just if anyone's ever questioning where the first couple racist laws were, it started with gun control, I'd argue. But
well, that's why the Second Amendment applies against the states, because the backdrop of the Civil War was how the 14th Amendment came to be. So that was a huge issue. Race issue was a huge issue back then.
Mm-hmm. And a lot of the laws during the Reconstruction era, again, they were. Yeah.
Did you study that stuff in college?
Sorry?
Did you learn that stuff in college?
I did do American history in college. Yeah. But I swear I learned more out of school than I did in school. And I think, my appetite for learning really developed a little bit later on. I tolerated learning in school as much as I needed to. I always tell people, for someone who hated school as much as I did, I really went through a lot of it. Like I said earlier, you can never stop learning. There's never a bad time to start. And I think, while I was aware and did learn, back in college and everything, I think just in the work I'm doing and the research that I've just done on my own, throughout the years. It's been a little over a decade now of that. And, that's, where you learn the most. Just pick up a
Yeah.
book, get an audio book. I used to just devour audiobooks on my LA commute back in the day, but
It's a good idea. And there's podcasts now, which is why we're doing this.
exactly, you learn a lot.
Well, John, we thank you for joining us and spending your valuable time as an active attorney. So your time is valuable by definition on talking us through the Miller versus Bonta decision and those issues with the California quote unquote assault weapon ban. Is there anything you'd like to say to close us out?
No, just thank you for having me. It was truly a pleasure. I had a great time, and always willing to talk guns and constitutional law.
Oh, we got to ask you, are you a 1911 guy? Well, first of all, are you a semi-auto guy or a revolver guy?
Oh, see, this is a problem. I always say I have gun ADD. Like I'll focus in on guns and I'll like certain guns. And I'm like, oh, that gun.
Yeah, so it's whatever's in
I
your
like
hand.
them all. I have 1911s. I have Glocks. I have single action revolvers, double action revolvers, lever actions, semi-auto rifles. The only thing I haven't gotten really into, which I still need to, is the long range shooting. And that's purely because I'm terrible. That anytime I have the money to buy a nice scope to really get into the long range stuff, I go and buy another gun. I mess that up every time.
Someone listening to this is thinking, he sounded really normal until then, just right at the end when he said he had a bunch of guns. I knew he was a nut.
Well, I'll give you a tip. So for all those who have wives that are very curious how many guns you have, the tip is to never, ever count them. Never count how many guns you have. That way, when your wife asks you, how many guns do you have now? You can honestly say, I have no idea.
Yeah, make sure you know where they are, but just
I know where everyone is, but I never counted them and I never will. I never want to have to lie to my wife. But how many guns do you have? I don't know. You have any idea? Never counted, never tried.
That's hilarious. That's awesome. John, you're a delightful activist, and it's obvious that you really enjoy what you're doing. And I think that a lot of people are kind of jealous because the joy exudes and comes out of your pores of your skin.
And it is fun. I do enjoy what I do.
It's great to have you on our side fighting in California. Thank you for what you do.
All right, well, thank you.